call Eugenie Sage.
Chair, e te mangai, and tēnā koutou katoa e te whare. Very pleased to take a call on the Earthquake-Prone Buildings Amendment Bill, and would like to talk in this call about heritage buildings, because Paul Foster Bell in his contribution outlined clause 23 in the new section 133AT, which outlines how the owners of our most significant heritage buildings, those with Category 1 status, all listed in the National Historic Landmarks Register, can apply to councils for an extension of up to 10 years to strengthen an earthquake-prone building. Now, the Wellington City Council is much further ahead than many other councils, obviously because of the earthquake risk in the city, in identifying earthquake-prone buildings. It's identified 684 pre-1976 buildings in the city. Of these, 137 have heritage listing, but only 21 have Category 1 status, and so they would qualify for an extension of time under clause 23. And it was certainly a major concern of submitters about the impacts of this bill on heritage buildings. One of the submitters, Phillimore Properties, noted that a large number of quite beautiful heritage buildings were on the market because their owners couldn't face the costs of earthquake strengthening, and because in cities like Auckland the land values are often worth more than the buildings. So there's a very real risk of heritage buildings being demolished in the wake of the legislation. And that would be a tragedy for cities and towns across New Zealand because of the contribution which many of our older buildings make to their character and identity. You only have to think of areas like Oamaru, Invercargill, the loss of heritage in Christchurch. And that's one reason that the Green Party is supporting the bill, but we're also supporting Ron Mark's SOP, because instead of weakening the regulatory regime which the bill sets out to provide, as Mr Seymour's one of his SOPs does, we've got to provide more incentives to the owners of heritage buildings so that there is some recognition of the benefit that the community gets from the protection of that heritage character, and to assist them with the costs of strengthening. And certainly the larger metropolitan councils like Christchurch and Auckland have already been quite proactive. In Wellington, the council set up a $400,000 fund, which is for built heritage, which is likely to be allocated on an annual basis to assist with the costs of earthquake strengthening. Wellington City Council also offers rates relief if a building is left vacant while that strengthening occurs, and offers some rebates on building consents. Similarly, in Christchurch, there is a built heritage fund to assist with conservation costs, which can include earthquake strengthening. But this is a relatively small amount of money given the many building owners that will be affected. So Mr Mark's SOP does highlight the quite significant gap in government policy here, and would welcome some comments from the Minister in the Chair in terms of whether the government is making any progress in considering some incentives for building owners for earthquake strengthening costs associated with heritage buildings. Because as the Property Council has pointed out, a building owner can claim a tax deduction for a building that collapses with the risk of quite significant injury or potentially death, but it can't claim a tax deduction for the costs of strengthening a building so that that injury doesn't occur. And so what we're seeing at the current time is those costs of providing incentives to the owners of heritage and other buildings falling on local councils, and the government not stepping in to actually help fill that gap. The Minister has said it would be premature to address tax reforms before the policy provisions around earthquake strengthening are in place and before the bill has passed. We think there could be a tax working party set up to address this issue, because obviously tax legislation was written before the whole issue of earthquake strengthening was considered. And as I understand it at the moment, You cannot claim a tax deduction for earthquake strengthening because IRD regards that as a capital expense because it is enhancing the building. But once this bill passes, that will be a legal requirement. Mr Chair.
Sage.
Thank you, Mr Chair. And earthquake strengthening is actually providing for the functioning of the building, so it shouldn't be regarded as an enhancement. And even if Mr Mark's SOP is voted down because it is outside or ruled out of order, as the Chair of the committee noted, because this is an omnibus bill, well, it's not an omnibus bill, sorry, we think the SOP is very timely in highlighting a major policy gap and the fact that the government needs to be giving some incentive, particularly for the owners of heritage buildings, to strengthen them. We have seen in Christchurch with the very infamous comments of the Minister, Jerry Brownlee, in calling a lot of our heritage buildings old dungers, and that leading to their demolition after the Canterbury earthquakes. But this SOP, we think, is a very useful initiative in highlighting the policy gap. And in the rest of the call, I would just like to highlight that we are very pleased with the changes that were made in Select Committee, and I've talked before about the very good process that both ministers and Scott Simpson, the Chair, undertook to ensure that there were good changes made, because the Green Party opposed this bill as it was introduced because it had far too generous exemptions for building owners for meeting the current fire and disability access requirements when undertaking earthquake strengthening, and we pushed very hard for changes here, and there were submitters who were very concerned about this. The Human Rights Commission said that it was just highlighting that we were undermining our good human rights record. We were, by this retrograde step of not ensuring that those disability access requirements were put in place. And there are a lot of submissions which presented evidence of heritage and other buildings which had been upgraded to improve accessibility without diminishing their heritage fabric, and recognition by groups like Age Concern that making sure that buildings are accessible promotes the well-being of all of the population, whether it is parents with pushchairs, whether it is senior citizens. It doesn't just provide a privilege for people who are in wheelchairs, but it promotes well-being for all of us, and it ensures that there are equal rights for all. So this change in the bill has been quite critical to the Green Party now supporting the bill and its progress. There'll be some other comments I'd like to make later, but we support the SOP that Ron Mark is lodged, and are very pleased with the changes around disability access. Thank you.
Ron Mark.
Chairman. In rising